Welcome to WorkCover Western Australia. This short video will help explain settlements and the process of entering into a settlement agreement during a workers' compensation claim. You may also like to watch our series of online videos for more information, including dispute resolution, what happens if there's a dispute, and injured workers, what are my entitlements? The majority of workers' compensation claims are finalised with an injured worker's full recovery and return to work. When this is not the case, some workers finalise their claim by entering into a settlement agreement to receive a lump sum payment from their employer's insurer. Before settling a claim in this way, you should ensure you understand the terms and conditions of the settlement agreement and consider seeking independent legal advice. A lump sum settlement may consist of several types of compensation, depending on what you're entitled to under the workers' compensation legislation. The lump sum may include compensation for income payments, medical and health expenses, and/or permanent impairment or dust disease impairment. If your injury has caused a permanent impairment, a settlement agreement must include an amount to compensate you for it. The amount of compensation is based on the type of impairment and its extent as assessed by an independent approved permanent impairment assessor. To enter into a settlement agreement, the approved settlement agreement form must be signed by all parties involved, including you and your employer or their insurer. The settlement agreement is usually prepared and lodged by the insurer or a legal representative. Once signed, the settlement agreement is lodged with WorkCover WA to be registered. It's then checked to make sure it complies with the workers' compensation legislation. If the settlement agreement is compliant, it will be registered and you will be sent a letter of registration. Once registered, your employer's insurer will pay you the lump sum according to the terms of the settlement agreement. Payment of the settlement sum must be made to you within 14 days from the date of registration. However, it can take longer if another law, including a Commonwealth law, prevents payment within that period. It is important to know 10% of the settlement sum will be deducted and sent to Medicare, who will check if any Medicare benefits were accessed as part of your claim. If there is nothing owing to Medicare, the withheld amount will be returned to you. There are significant consequences associated with entering into a settlement agreement. 1. You will not be entitled to any further compensation for the injury. This includes medical and health expenses and income compensation payments instead of your wages. 2. You will not be able to pursue common law damages against your employer. This will be explained shortly. 3. The settlement agreement may affect other benefits and entitlements, such as Centrelink, Medicare, tax, or private health insurance. As such, it is recommended you seek independent legal advice before entering into a settlement agreement. If your injury is significant and you can prove it was caused by the negligence or fault of your employer, you may elect to pursue damages against your employer through the courts. This is called a common law claim. You can only pursue this option if you have a whole-of-person impairment of at least 15%, as assessed by an approved permanent impairment assessor, and you lodge a common law election form with WorkCover WA. Common law claims can be settled by agreement at any stage prior to a judgment being made. Common law claims are complex and may affect your workers' compensation entitlements. It is strongly recommended that you seek independent legal advice before electing to pursue a common law claim. Remember, you cannot pursue common law damages against your employer if you accept a settlement. WorkCover WA cannot provide advice on settlement offers and whether you should enter into a settlement agreement. However, if you would like further information on settlements, you can speak with one of our advisory officers by calling 1300 794 744. We also have a range of publications and resources available on our website.